hospital, and while I don't want to disadvantage the people of Donegal, the reality is it's 20 miles from Derry. So I would hate to see us make the same mistake that we made on cancer care. So I would ask that you use your good offices to impress that upon. Thanks.
Next is Senator Jillian van Turnhout. Are you taking this, Minister?
Yes, I take this of Minister Stafford.
4 minutes.
Thank you very much, and welcome, Minister. And I do need to express my disappointment that none of the adjournment matters that I've raised on direct provision have been heard by the Minister with direct responsibility, but I do welcome, Minister, that you are here today. The system of direct provision, Minister, has been in operation since April 2000. However, there are concerns that there is no legislative basis for the operation of direct provision. With the Ombudsman's concern about the operation of the former Mobility Allowance Scheme, it's essential that the rule of law operates in all aspects of our social welfare code. When initially introduced 13 years ago, direct provision was viewed at the time as a limited system that would be for a maximum of 6 months. However, the legal basis for this system is now wholly unclear. When it was initially introduced, it was argued that the direct provision system was permitted by providing supplementary welfare allowance in kind rather than in cash for asylum seekers. Asylum seekers were offered bed and board by the Reception and Integration Agency and provided a weekly allowance of €19.10 per week per adult, with €9.06 per week per child, an amount that has not changed since 2000. Since the introduction of the Social Welfare and Pensions Miscellaneous Provisions Act 2009, asylum seekers cannot ever be considered habitually resident in the state. Since access to most welfare payments, including supplementary welfare allowance, is now restricted to those who are habitually resident in the state, and since asylum seekers cannot be considered habitually resident, what is the legislative basis for the continued accommodation and payments made to asylum seekers? Dr. Liam Thornton of UCD School of Law, a researcher on the law and policy of direct provision, has recently published an article about the dubious legality of the direct provision system. This article notes that in 2006, the then General Secretary of what is now the Department of Social Protection, Mr. John Hines, raised concerns with the then Secretary General of the Department of Justice and Equality, Mr. Sean Aylward, that the regular direct provision allowance payments made to asylum seekers were outside the powers or ultra vires the Department of Social Protection. And according to Freedom of Information documents received by Dr. Thornton, an attempt was made in 2006 or 2007 to place the direct provision payment on a legislative footing. However, this was then abandoned. A copy of Dr. Thornton's article, the correspondence between the Secretary-Generals of the Department of Social Protection and Justice and the draft legislation, can be provided to you, Minister, if you wish. I have them all here. It is necessary, I think, for the Minister to provide clear assurances that the direct provision system has a clear legislative basis under Irish law. It's a matter for me of serious and continuing concern that a system whereby individual families, and in particular children, are allowed to languish for several years without any definitive decision being made on their entitlement to remain in the state. I do note and welcome the IRP bill, but that has been in committee stage in the Dáil since 2010. We're 8 years and counting for this bill. So for me, what needs to be clearly explained is what is the legislative basis for the continued operation of the direct provision system.
Before I call the Minister, I'd like the members and the Minister to join with me in welcoming the Right Honourable Rambuts from his consulate from Antwerp. So you're very welcome to the distinguished members gallery. So, Antara?
Yes, I recognise the tie.
You're very welcome, sir. I'm responding on this subject today on behalf of my colleague, the Minister for Justice and Equality, Mr. Alan Chatterjee. The question asked by the Senator in her motion presupposes that there must be a specific legislative underpinning for the provision of state services to persons who otherwise would not be entitled to such services. Legislating for legislation's sake is unwise. If there is a case being made for a change in how asylum seekers are accommodated, and this is a view which the Senator is expressing and has expressed on a number of occasions, then that is an issue of policy in the first instance rather than legislation. The direct provision system ensures the delivery of services alongside legislative provisions which would otherwise specifically prohibit asylum seekers from being provided with the basic necessities of life. For example, asylum seekers cannot work under Section 9(4)(b) of the Refugee Act 1996. They cannot access rent allowance under Section 13 of the Social Welfare Miscellaneous Provisions Act 2003. They are not entitled to a range of benefits including the child benefit, as they are deemed not to be habitually resident under Section 2467 of the Social Welfare Consolidation Act 2005. As an administrative system, direct provision is unique in this state, but as a result of it, no asylum seeker has ever been left homeless. Clearly, it's not a system without its faults, but in the 13 years of its existence, over 51,000 asylum seekers have been accommodated under this system. Asylum seekers receive nourishment on a par with, and in some cases superior, to that available to the general population. Asylum seekers receive a health service on the same basis as Irish citizens, and it is in many cases far superior to what is available in their countries of origin. Children of asylum seekers are provided with primary and secondary education in the local community on the same basis as the children of Irish citizens. The system of direct provision is not unique to Ireland. Many other countries operate similar systems for meeting the reception needs of asylum seekers, and all face challenges which are broadly similar to the issues we face here. There are no cheaper alternatives to the direct provision system. In fact, if we were operating a system which facilitated asylum seekers in living independent lives in individual housing with social welfare support and payments, the cost to the Exchequer would be double what is currently paid under the direct provision system, even discounting the additional pull factor this would entail. This was a key finding in the Value for Money report in 2010. Allowing asylum seekers access to the full array of welfare and housing benefits would run a real risk of a large upsurge in economic migrants masquerading as asylum seekers, coming here in the expectation of accessing these services. Furthermore, in respect of any major change of policy, we have to take account of the common travel area between Ireland and the UK, which facilitates free movement between the jurisdictions. It must be borne in mind that the persons residing in the direct provision are here for a specific reason, to claim international protection from this state. That entitlement is protected by international obligations which the state has entered into, and by a comprehensive national and EU legal framework and accompanying administrative processes which govern the processing of protection applications. The Minister acknowledges that there is an issue with the length of time applicants spend in direct provision. While not suggesting that applicants are not entitled to the protection of the courts and due process, a consequence of the frequent recourse to the courts to challenge decisions under these legislative processes is to extend the length of time spent in direct provision accommodation. This underlying problem does not arise from a lack of legislation. Quite the opposite. There are many reasons why applicants spend lengthy periods in direct provision. I've already referred to legal challenges being one of these. Undoubtedly, another significant issue is the cumbersome and multi-layered legal protection process in the state. There is a clear imperative to change and radically reform that process, and the Minister is committed to introducing that reform. As the Minister has already stated, he intends to republish a revised Immigration, Residence and Protection Bill, which will substantially simplify and streamline the existing arrangements for asylum, subsidiary protection and leave to remain applications. It will do this by making provision for the establishment of a single application procedure so that applicants can be provided with a final decision on all aspects of their protection application in a more straightforward and timely fashion, thus reducing the length of time applicants spend in the direct provision system. Pending the enactment and commencement of the new legislation and with a view to improving processing, the Minister informs me that he is proposing to introduce new arrangements for the processing of subsidiary protection applications in light of recent judgments in the Superior Courts. His department, in consultation with the Attorney General's Office, is developing a new legislative and administrative framework for the processing of current and future subsidiary protection applications. This work is being given high priority, and applicants will be advised of the new arrangements as soon as possible. In the meantime, the system is overseen by the Reception and Integration Agency, the RIA, of the Minister's Department. RIA is subject to the same civil service obligations of fairness, of implementation of policy, as would any area of government implementing a scheme, either statutory or non-statutory. Finally, it is worth noting that since the Minister took up office, the number of persons being accommodated in direct provision has fallen significantly by approximately 1,000 people, or 25% in the period in question.
Brief question, Senator.
Just very briefly, just obviously maybe my question wasn't clear enough, and perhaps I will take it up again with the Minister for Social Protection, because the 2006 correspondence between the Secretary General of the Department of Social Protection at the time to the Department of Justice said that the payments made to asylum seekers were outside the powers or ultra vires of the Department of Social Protection. And obviously, in light of the Social Welfare and Pensions Miscellaneous Provisions Act of 2009, it clearly says asylum seekers cannot ever be considered habitually resident in the state. So my question is how is the state making these payments? And I will address that question. I just advise the Clearlock that I will be putting in a question then to the Minister for Social Protection, because while I appreciate the response, it does not answer the question that I asked.
Tara, do you wish to comment any further?
Further note here too, because I think the Minister would like to be here himself, but he can't be. You know, and I acknowledge on his behalf the points made by the Senator in her contribution, but it's essentially not about legislation, it's about policy, and I think the Senator herself is emphasising that in her follow-up. And the reasons behind that policy have remained unchanged. The direct provision system did not come about by accident. It was a necessary response to the increasing number of asylum seekers arriving into the state. Before 1999, these asylum seekers were treated as homeless under the then structures in place. These structures were entirely unsuited to the situation facing Ireland, and the homeless service of the then Eastern Help Board could not cope, and there was a serious prospect of widespread homelessness amongst asylum seekers. The direct provision system is only one element of the state's response to its international obligations on the asylum issue. As well as educational, health and welfare costs, there is the asylum determination system itself, as well as the downstream judicial and policing costs. Quite clearly, meeting our international obligations in this respect consumes very considerable public monies. But Ireland is not unique in this respect. All countries which take their responsibilities in this area are seriously faced with similar calls on their financial resources. The RIA's role is to adapt to circumstances in ways which specific legislative provisions perhaps could not anticipate. In recent years, it has introduced child protection measures, including Garda vetting, and will, in the coming months, begin to publish on its website completed inspection reports on each of the centres under contract to it. Excuse me. It has also to adapt to the decline in persons seeking accommodation. In the 4-year period between 2009 and 2012 inclusive, the RIA closed 25 centres and was accommodating 2,161 fewer persons. This flexibility and adaptability of the direct provision system would not be enabled, but would possibly be hindered by a specific legislation underpinning it.
My question is about the legal status of the payments that are being made. It is not about the legal status of the policy, so it is about the payments, which was not addressed. But I do appreciate, Minister.
Can I give the Senator undertaking? I will chat away this.
Thank you, Cahirlock. I'll just wait for the Minister who's taken this much time.